Welcome to the third of the series of webinars organised by the Queen Mary Intellectual Property Research Institute. Previously in our webinars, we've examined why COVID-19 presents different problems from previous access to medicines imperatives and why it requires different solutions in terms of IP responses. We also, in our second event, looked at how technology can assist with the COVID-19 response and whether intellectual property can facilitate, or alternatively, whether it creates barriers in terms of access. And in this third webinar, we're going to focus on how better coordination in terms of access can be achieved, particularly taking into account the public interest. And our four speakers today are going to address those broad themes in their presentations. So the format for today's event is that I'm going to introduce the speakers who will each talk for approximately 10 minutes. If you would like to ask questions, please use the chat function on Zoom, and I'll put those questions to the speakers in my capacity as the moderator. And then we'll have, at the end of the presentations, a panel discussion at which, again, we can usually raise additional questions. So without further introduction, I'm going to hand over to our first speaker. Rochelle Dreyfuss is the Pauline Newman Professor of Law at New York University School of Law, and currently holds the Arthur Goodhart Visiting Professorship in Legal Science at the University of Cambridge. Rochelle, over to you.
Okay, well, thank you, Duncan. So I was asked to speak about coordinating access during the COVID pandemic in a manner that's consistent with the World Trade Organization's TRIPS agreement. Now, access means two things: access to treatments, vaccines, and equipment once they're developed, but also access to the materials needed in order to invent those things. Both raise coordination and TRIPS questions. And I'll talk mainly about invention, and then Henning, Grosse, Ruse-Khan, who follows me, will talk about distribution. To be sure, some of the necessary materials are in the public domain. An example is polio vaccine, which is being repurposed with some success. But much of what's out there is already protected, including drugs, ventilators, PPE, that could be modified to deal better with COVID. There may also be existing rights over genetic and proteomic sequences and gene editing techniques and important mutations to the coronavirus. And of course, all the newly invented stuff can be patented. Furthermore, regulatory information on safety and efficacy is subject to a regime on data exclusivity. Of course, there are initiatives to donate technology to the public, despite these rights, at least during the pendency of the pandemic. And there are several initiatives along those lines. The Research Data Alliance, involving the United States, EU, and Australia, has promulgated the COVID-19 guidelines on sharing data. The World Health Organization, WHO, has an initiative, the COVID-19 Tools Accelerator, to pool materials. The World Bank is involved with philanthropies, other organizations and governments, and Gavi, the Global Vaccine Alliance to develop vaccines, and CEPI, the Coalition for Epidemic Preparedness Innovations. Various national regulatory authorities have formed ACTIVE to share and monitor data on safety and efficacy. And there are various private-public partnerships that also are sharing data. But research is expensive and risky, and some research firms have labeled the idea of sharing and pooling nonsense. They are investing in the hope of making money, and they plan to seek exclusive rights and to enforce them. Now, of course, domestic patent laws include provisions to deal with these problems. There are experimental use exceptions for researchers. There are exceptions for generic producers seeking regulatory approval. There's Crown and government use rights, which could cover researchers and also patients. There are compulsory licenses, which Henning will talk about. Some countries have elevated the criteria for patentability. So in the US, genetic sequencing information is considered in nature and not a technical contribution. India and Latin American countries have defined invention or inventive step to exclude patents on new uses of old substances. And in some countries, competition law deals with right holders who refuse to license in the public interest. But these measures are enacted by individual nations. No country can control what happens outside its borders. And some measures, for example, international exhaustion, can have negative externalities. So it might improve access locally, but incur costs elsewhere or raise costs elsewhere. Most important, for WTO members, all of these measures are subject to the TRIPS agreement. And the TRIPS agreement was the product of a particular moment in time and the theories about creativity, the economy, and trade that were prevalent then. A very individualistic concept of invention, a view that saw exclusive individual rights as crucial to motivating creativity, and a consensus that allowing right holders to choose where to produce would reap comparative advantages, make the global economy more efficient, and the world so interdependent there would necessarily be peace. What epidemics and pandemics have taught us is that none of this is always true. On the happy side, it turns out there are important incentive systems that have nothing to do with monetary rewards. For example, many scientists have worked under the WHO's Pandemic Influenza Preparedness Framework, the PIP framework, and have found that such work furnishes hedonic benefits for helping others, reputational benefits from scientific discovery, networking benefits, opportunities to learn new research techniques, and create inputs like reagents useful in other work. Now, of course, it has to be structured properly to do that, but the PIP framework shows that that's possible. But we've unfortunately also learned that comparative advantage and efficiency aren't all that cracked up to be. Redundancies to experiment, in manufacturing and distribution are needed to ensure that the best research gets done and that supplies will be adequate for everyone. Moreover, when push comes to shove, what we see is vaccine nationalism and not global peace. Now, of course, the TRIPS agreement has many flexibilities. It leaves it to member states to define technological invention, inventive steps. There's a general exceptions test in Article 30, and there are several exceptions to protect health. Article 27.2 allows states to make certain exclusions from patentability for health reasons. 27.3 allows exclusions for diagnostic and therapeutic treatments, and 39 lets states waive data exclusivity when necessary to protect the public. And there's also a security exception in Article 73 for actions taken to address an emergency in international relations. But so far, TRIPS has been interpreted in light of that original individualistic understanding, which leaves little room for sharing and international coordination. Consider, for example, Article 30. It requires that exceptions be limited, not unreasonably conflict with normal exploitation, not unreasonably prejudice the legitimate interests of the right holder, taking into account third-party interests. In the WTO's Canada Pharmaceuticals report, the panel construed this quite narrowly. It said the test is cumulative, so if an exception isn't, say, limited enough, the interests of third parties like patients are never considered. So the stockpiling of pharmaceutical products in anticipation of patent expiration wasn't allowed, even though it would have provided worldwide benefits to patients. Legitimate interests is a broader category than rights. So for example, it could include the power over research uses. Under that view, other flexibilities might similarly be considered quite narrow. But that might change. First, after Canada Pharmaceutical, at the start of the Doha round, the WTO issued a ministerial declaration stating that the agreement shouldn't be read to prevent members from taking measures to protect public health. That must be interpreted in light of its object and purpose, and most interestingly, that each member has the right to determine what constitutes a national emergency. Moreover, the appellate body, AB decision, and Australia plain packaging accepted the Doha Declaration's view that Articles 7 and 8, which specifically refer to health, can be used interpretively. That's something the panel and the Canada case didn't do. In the plain packaging case, the AB allowed Australia to severely restrict how trademarks are displayed on tobacco products in order to protect health by discouraging smoking. Nonetheless, I doubt that states now enjoy carte blanche. There's a proviso in Article 8 that the measures taken must be consistent with the agreement. As important, the AB did not consider the flexibilities taken to protect health as self-judging. Rather than accept Australia's decision that the measures would protect health, or even the recommendation of the WHO's Framework Convention on Tobacco Control, the panel and the AB took their own very hard look at the science supporting what Australia did. In addition, last month in the Saudi Arabia IPR report, a panel stated that even emergencies under Article 73 are not self-judging, that because countries must interpret the TRIPS agreement in good faith, the panel has a duty to evaluate the respondents' claims for plausibility. Now, it may well be that WHO's declaration of a pandemic is sufficient to make plausible all the arguments about every measure dealing with COVID-19. And Henning will talk about whether at least some of the flexibilities actually are self-judging. But even if there's no TRIPS problem, many states have entered into bilateral and plurilateral free trade agreements that reek of the same individualistic consensus. They're even more protective of IP rights than TRIPS. For example, they usually require patents on new uses of known pharmaceuticals, some limit the availability of exclusions from patentability, and many have different security exceptions. To be sure, because of public relations or geopolitical considerations, states may not challenge each other's COVID-inspired measures. However, many bilaterals also protect investments, and all of these define investments to include IP. That means that investors may bring challenges, and they may not be as cautious as states might be. In these disputes, measures will be judged on a different metric, on whether they amount to an indirect expropriation or denial of fair and equitable treatment. And they'll be judged by a different sort of decision maker, a commercial arbitrator. At least one tribunal has suggested that dramatic changes in the law amount to a denial of fair treatment. This is an older case. But all that means that all of the moves we are suddenly seeing could raise problems. Of course, there's a talk of a moratorium on these investor state cases for the duration of the pandemic. But it's hard to know how that will work or what will happen once the pandemic ends. Certainly, we need cooperation if the pandemic is ever to end. We are none of us safe until we're all safe, so we have to hope for the best and that things can be shared. And for that, I'll turn it over to Henning, who is much more optimistic about all of this than I am.
Thank you, Rochelle. Very succinct and helpful introduction to the topic today. I'm now going to hand over to our second speaker, Henning Grosse Ruse-Khan, who is a reader in international and European intellectual property law and also co-director of the Center for Intellectual Property and Information Law at the University of Cambridge. Henning.
Thank you very much, Duncan, and thanks for inviting me. So to pick up on Rochelle's points, not too sure if I'm that much more optimistic in terms of overall outcomes, perhaps on some of the individual bits of legal analysis, which are still sort of open, or where we have some degree of guidance from the appellate body or from panels, or maybe in the Doha Declaration itself. But we'll leave that maybe to individual bits of my talk in a moment. So I want to make essentially three main points, and I'll sort of elaborate on them after having sort of initially made them. So the first one is that the existing international IP framework does allow, I think, individual states to take measures, in particular in the form of compulsory licenses, that facilitate access to medicines, and that would include COVID-related treatment. But the key issue here, I think, is that many countries will not have sufficient means to actually manufacture the type of medication, especially a vaccine, which may be a more complex molecule, a biological drug, at home, and therefore are in need of support from other countries which have that manufacturing capacity. And then there's, of course, a legal question about the extent to which that is possible. I'll look into that. But there's a probably more, bigger economic and practical issue about the extent to which countries are actually willing to supply other countries. And if you look at the recent move by the United States to buy up the stocks from remdesivir for the next 3 months, I think you already see at least some countries, and the EU is no better in that regard, when you look at its program, essentially trying to ensure what some have referred to as vaccine sovereignty or vaccine nationalism, that their own populace is served in full first before any other supplies can go elsewhere. But that's an issue I'm not going to look into so much. So I'm going to look at the legal dimension about whether a coordinated access mechanism is at all feasible within the international IP system. And here the second point for me is that the international IP system is primarily designed in a way that it limits to intellectual property rights, like exceptions, but also compulsory licenses and other limits. They primarily operate on the domestic level. So there is, to some extent, I'll say a little bit more about that in a moment, a lack of coordination when it comes to limiting IP rights, while we at the same time, of course, are very good in, or at least reasonably good in, coordinating protection. When it comes to the limits, they primarily operate on the domestic level, and maybe COVID is a reason to rethink that. So that's, I think, one of the main points I want to make. And then the third one is, and that picks up on Rochelle's last point, is that even if the international IP system does, on a multilateral level, allow us to take measures, allow states to take measures, maybe even to coordinate access to some extent, the question remains whether these measures, the domestic ones or even the coordination measures, are subject to additional layers of protection, for example, under the international investment regime. And I'll say a little bit more about that, and just picking up on one or two points Rochelle already made in terms of legal stability protection and whether something which is perhaps a dramatic change in the domestic legal framework could be seen as a relevant challenge under investment protection. The key point here, of course, is that IP rights tend to be considered as investments under investment treaties. They're not always in the pure form of a registered right being protected as such. Maybe some more engagement of the investor is required, but that's the default position to start from. And that's why looking at investment agreements is an additional layer of protection one has to take into account. So my main proposition in that sense is that we need to think more about, especially within the international IP system, about not only coordinating global protection, but also coordinating efforts towards access and dissemination. And that we also need to think about the implications of layering these types of protections in the sense that we have IP treaties, yes, and we have bilateral agreements on top of that, yes, but then we have investment protection, or perhaps even in addition to that, constitutional protections of property, but it's probably more the investment protection which can be problematic, especially if you compare some aspects of that regime to aspects of the international IP regime as we know it. So maybe one more word about coordinating access as a sort of systemic issue and how the international IP system positions itself here. And then I'll speak a little bit more on particular flexibilities and their limits, including limits from investment law. So when it comes to coordination, I think, and that's the main theme from what I understood from Duncan for this whole session, international IP law, by setting minimum standards, of course, effectively requires individual countries to implement and make these standards available in their domestic national regimes of intellectual property protection. But as I indicated earlier, when it comes to limits to these standards, there's little coordination, and mainly this is left to the national legislatures, because of course we have a territorial system of intellectual property protection, so that's perhaps the default position. But then there's also little effort being made to coordinate access. There are some exceptions to this, and you could look at the Marrakesh Treaty on copyright exceptions for visually impaired persons, which essentially allows cross-border trade in copyrighted works in accessible format, so that you could see as an attempt to essentially coordinate access on an international scale. And in our context, in the access to medicines context, you could look at the Article 31 bis mechanism. I'll say a little bit more about that in a moment. So this is in principle a mechanism where one country which doesn't have sufficient manufacturing capacity is able to ask another country to issue a compulsory license and then to eventually export the products produced under this license to the country in need. So that's a bilateral mechanism, but in my view, not a sufficient internationally coordinated, or doesn't allow for sufficient international coordination. And as Rochelle ended, in the current COVID context, probably we need to think much more about international coordination of access, because if an outbreak anywhere is a risk everywhere, as the New York Times says, then we're not really safe until everyone is safe, right? So there's a utilitarian argument, but clearly also a humanitarian argument for coordinating access. So that's the sort of point about coordination. Now let's look first maybe at the flexibilities within the TRIPS agreement to issue, for example, compulsory licenses. I'll focus on that for the interest of time, and I'll say a little bit about that mechanism under Article 31. And I think the key point here is to say that TRIPS Article 31 as a provision allowing compulsory licenses does not determine the grounds on which countries want to issue a compulsory license. Article 31b allows to sidestep the usual requirement for prior negotiations with the right holder in cases of national emergency. Doha Declaration said that this is mainly a self-determined mechanism. One could then debate whether Doha's legal status would allow a country to directly rely on Doha in order to say that this needs to be something to be self-determined. But I think in any case, if it's a national emergency, the country declaring that an emergency is best placed to consider whether it is in such a state of emergency. And I think that can be distinguished from Article 73, which talks about an emergency in international relations, where that is the sole objective test for that type of general security exception to come in, where the rest of that provision, Article 73, is essentially a self-judging or mainly self-judging mechanism, and therefore the objective test for there being an international emergency is probably a warranted test there, whereas national emergency, I think in Article 31b, is probably something which is in fact more to be determined solely by the country declaring that. So the point I think I want to pick up under Article 31 then is the need for, under a compulsory license, nevertheless to provide for adequate remuneration. And that is something which kind of links us back to this idea of TRIPS being an open contract, because adequate remuneration is not further defined. Countries could probably take different positions on that. There is guidelines, various types of guidelines, I suppose, but there are some from the WHO and UNDP from 2005, which suggest that royalty rates between 1% and 5% of the retail price of the generic drug would constitute such form of an adequate remuneration. However, and that's what I want to sort of mainly make as a point in linking this to the investment protection regime. If you contrast that kind of a standard, adequate remuneration under TRIPS, with the need to provide full compensation at the market value of the investment as the standard under, for example, expropriation protection in investment law. And if you then have arguments about compulsory licenses potentially constituting an expropriation, you already see that probably this full market value standard is significantly higher and requires significantly more compensation than the TRIPS regime may do. And I just want to highlight one particular case. It's got nothing to do with compulsory licenses or with IP, very little with IP. This is an award in the Tethian Copper versus Pakistan arbitration, an international investment arbitration, which was decided under the Australian Pakistan BIT and under ICSID. It's essentially about Pakistan denying a license to develop a certain gold and copper mine in the region of Baluchistan. And the point I want to make here is that the tribunal eventually issued an award in favor of the investor at $5.84 billion US, right? So that's $5.84 billion US awarded against Pakistan, $4 billion US in damages based on using the so-called discounted cash flow valuation method. The investor had, by the way, actually initially claimed 8 billion, plus another 2 billion in interest, almost 2 billion in interest and legal fees, right? That represents 13% of the state budget of Pakistan, and it's 15 times the annual education and healthcare budget combined. So that number, just even though it's an extreme example, shows you how significant the freeze or the put it that way, how significant the implications of such an award can be for a country, especially for a poorer country, if they have to pay these kinds of money, and these kinds of awards are enforceable through ICSID or otherwise potentially through the New York Convention. So it potentially freezes the ability of a country to introduce public interest policies. And as I said, this is an extreme example, but I'm raising this because it is such a significant amount, and in my view, needs to be mentioned as a sort of potential outcome in investment treaty arbitration. So Duncan, I think I'm almost sort of out of my time, but let me just say a little bit, maybe 2 minutes if I can, about the Article 31 bis mechanism about coordination of access. So this is the situation which I mentioned before about one country not having sufficient manufacturing capacity and asking another country to supply under a compulsory license, maybe a vaccine or others. And even if the country that supplies and has capacity is willing to do so, the Article 31 bis mechanism establishes a regime under which that can be implemented, but it's basically a bilateral mechanism. So one country supplies to another country. There's a small sort of, broadening of this bilateralism towards a regional distribution under an RTA clause, so a regional trade agreements clause. So where if the majority of members to that regional trade agreement are least developed countries, then they can be all supplied under that mechanism. But that would only actually, to my knowledge, capture very few regional trade agreements in Africa where you have that kind of combination of countries with the majority being LDCs. So that mechanism is there, but I think insufficiently allows to treat this current situation. There's something else to be said about potentially overriding limits under this mechanism by reference to the security exception under Article 73. Here the key issue would be whether or not the COVID pandemic constitutes an emergency in international relations. And while that is, I think, as Rochelle already indicated, not a self-judging element of that provision, and there needs to be some objective evidence for that, there could be, I think, little doubt that this is at the moment the case. One would probably have to look into further the degree to which a WHO declaration of a pandemic per se satisfies this, or whether one would have to look further into other elements of this kind of emergency situation. But I think overall, there's going to be, I think, a strong case for relying on Article 73 here. So that would be an additional mechanism.
Henning, that's fantastic. I'm going to stop you there because we're at 14 minutes 30. But that was fantastic. Tour of the key issues. I particularly wanted to intervene because we've had some really interesting questions online. So before I hand over to our next speaker, both for you and Rochelle, a couple of questions came through which you might like to comment on. One of them was from David Felipe Alvarez, who asked, do you think that for international coordinations, issues based on human rights prevalence should be considered as part of the framework to argue and even eventually force some states to cooperate when they face the pandemic?
So, I mean, my view on that briefly, and then maybe handing over to Rochelle. So you can see that in the Marrakesh Treaty, with the example which I gave for an international coordination mechanism within IP law, that in the preamble of that treaty, I think for the first time in an IP treaty, you have reference to human rights, the rights of persons with disabilities in particular. Now, I think there's for me, I think the question is whether the end result in the IP treaty then actually properly caters for these human rights, because human rights in themselves often don't have adequate enforcement mechanisms on the international level, and whether introducing them into the IP system actually leaves the rights properly intact, or whether they are kind of sidelined and part of exceptions, like in the Marrakesh Treaty. Everything under the Marrakesh Treaty is subject to the three-step test, which Rochelle already discussed, and then it's a question how we interpret that test. So I think it depends on the outcome, and whether that actually then does anything significantly good. But Rochelle,
do you have anything to add? You're muted, Rochelle. If you could just unmute your mic.
So the negotiation history of the Marrakesh Convention shows, I think, very little sympathy for human rights and IP. You also have the fact that IP is itself a human right under a lot of these agreements, the Universal Declaration of Human Rights, et cetera. And so it's always going to be a balance between the two of them. And I mean, perhaps with the COVID epidemic, we'll see human rights on the access side winning more often, but so far we just haven't seen that.
Mm-hmm. Okay, thank you. And I would refer the participants also to the discussion in the chat box as well. Julian Kinderala from University of Cape Town and Sangeeta from TWN have also been posting information there, which I think is also very helpful. We can return to some of these discussions, I think, in the panel at the end of the session, but I want to hand over now to our third speaker today, Roya Gaffele. Roya is the director of Oxfirst, an advisory firm specializing in law and economics. And Roya, I want to mention also that I noticed that for the third year running, Oxfirst has been awarded the prize for the best IP valuation firm in the UK by the Global 100 Awards. So congratulations on that. And we look forward to your talk.
Oh, thank you very much. Thank you for the introduction, Duncan, and thank you for putting this initiative together. Like all of you, I have been basically in self-confined for the last couple of months, have not left my home, and it's been tough. And I really just wondered, what can I do? How can I contribute with what I know to help resolve this situation? Because there's not really a point about talking about anything else right now until we all can just go out and have normal lives again. And I hope at least that this webinar is a little bit of a contribution, but I think much more will be needed. And no matter what skill set or competence people have, I would hope that we'd come together, collaborate, exchange, and think how on earth we're going to get out of this situation. I thought that the talks from Rochelle and Henning were incredibly interesting. They are looking at the big picture of global governance. I have worked in Geneva for WIPO for many years. Before that, I was actually involved in the FCTC under Dr. Derek Yack in a different life. And I did my PhD on the WTO. And what I have seen in practice is all of these things take forever. We don't have that time. Any type of multilateral discussions and negotiations to come to grips with whatever are such a long shot. By that time, it's all going to be gone. What we need are quick, pragmatic solutions which are operational right now and which help people to just figure out a way that we can work and live again normal lives. So I think what I've been trying to contribute to this debate is to think how can we come to grips in a bit of a quicker shot rather than having very long multiple multilateral discussions in Geneva and other places in the world, which in the worst case scenario need to be decided by consensus, which means it will be incredibly hard to find a solution. And can then in the end, I wonder what the relationship is then going to be also by bilateral free trade agreements, which seem to be somehow enable people to circumvent in some way the multilateral framework. Also, what will it mean when members such as the United States are leaving the World Health Organization? What power of decision-making does WHO still have? So what I want to focus in on my talk is the question of what we can do to improve research output and how intellectual property can help in achieving this. Interestingly, when I pitched my ideas to the main press, I was told this is just some esoteric area of law and not of interest for the general public. The Times got back to me 6 weeks after my paper was already long published, saying it's actually interesting, but we just had a very brief article on something from the WHO, which seems to be something about compulsory licensing. We're not really sure. And we think with that, we have really covered the topic. And I sent back to the journalist that I really don't agree with you. But he said it's not a main topic, and I think the first thing we'd have to swing is to sort of like make it clear to people IP is a major topic. It's not some sort of like sub-issue of a sub-issue for some geeks. And the way we can maybe achieve it is to get the pitch across in a non-jargon way to people who have the power to make decisions, because what we need for all of these things to happen is political will and the motivation for countries and corporations to work together. If we are not having that political will, and if there are going to be further bigger political tensions that prevail, it is really going to be counterproductive for everybody. So against this context, if you think about the generation, about the value chain of IP generation, of knowledge generation, you need to keep in mind that it's public-private partnerships play a major role. Universities are at the source to a large extent of IP and knowledge generation also in this area. But a university does not have the capacity to pass on all this knowledge into the market directly. A university doesn't have the product facilities, it doesn't have, I don't know, the product distribution channels. For this, it needs a company. So the relationship, between companies and universities and how they are being managed, I think is instrumental in achieving an output that will assure that we get quick results, good results, and that results for a cure for COVID-19 are available to everyone on this planet. And here, I think you need to keep in mind that universities and business have to a large extent different interests and different motivations. And the art is to manage these different tensions in a way that it will be beneficial to society and humanity. If I look quickly from a university's perspective, most universities have an obligation to protect the public interest. After all, many universities around the world get funded through the public, and what may be counterproductive is if research that's first funded with public means then gets passed on to a company who then sells it back to the public, but with a significant profit margin. I think there somewhere in this value chain, there's a disconnect where someone needs to recognize that this was in the first instance made possible through public funding and shouldn't be redisseminated with a seriously makeup to the public again. Universities research is also characterized by the fact of having a lot of IP in many different areas, which is simply reflecting the fact that the university is driven by people who have fun with their research, and nobody is dictating an institute to just do research in a very concerted specific field, which would then allow to have a concerted patent portfolio, which may be a strategy a company may want to pursue. So many universities have patches of IP, and I think what can help tremendously is if these various patches of IP are being put together, rather than have a little bit of patents on some specific stuff in Japan, a little bit in the US, and a little bit in the UK, and somewhere God knows where, and everybody does their own thing. It's just going to be, because of the very nature of how university research happens, it's just more productive if these universities aggregate their patents eventually and have a more concerted portfolio, and then look concerted in a joint way how to pass on that technology to the companies. The companies, again, are kind of different animals. They are often listed on the stock exchange. They need to make profits. They need to make sure they succeed in the market. If they're not able to do this, they go out of business. So for a company, it is very hard to just say, look, it doesn't matter, we'll offer all our facilities for free and we'll disseminate everything for free, because that's just not a viable way for a firm. So how you're managing the profit motive is, I think, instrumental. And there, a university has the power to state its claim and to say the way I want to structure the technology transfer agreement is that I want to assure that there's adequate access for patients in developing countries, that poor parts of society are given adequate access to the intellectual property, and that there are a whole bunch of exceptions fiddled into the contract, which assure public health and health for all, which is the aspiration of the World Health Organization. But strange enough, I'm not seeing this enough. I'm seeing quite a bit of, I mean, there are obviously historical examples where it has happened. Yale recognized this in one of its deals, and the company Remdesivir, or the Remdesivir eye drugs are actually already, it has been assured that they will be available for free at lower cost for patients in developing countries. But what would be really needed is a more systematic thinking among the universities and their tech transfer offices of how they can assure better the public interest. And I think this is looking at the public interest of IP ex ante, rather than looking at it ex post and looking at remedies such as a compulsory license, which in the end is a massive interference in markets. Looking at it from the outside is a little bit less harsh for everyone. And it's not happening enough. And I think from this, it comes in and by itself and is self-explanatory that you cannot work within national borders. You need to have the freedom to work internationally and have global alliances. And I think it goes without saying, having just narrow national boundaries among universities is not the best research strategy. And as a practical step to figure that out, I think there would be a certain need for awareness raising. Maybe in the UK, the Intellectual Property Office could issue some guidelines for tech transfer offices of how to better manage the public interest. I also think there's a point about how universities value their IP and how they set the licensing rates in case they want to license their IP. From what I've seen so far, this is a bit a black spot generally speaking, but when you then say, and most universities are not super, like how they're really valuing their licensing rates is a bit coming still out of thin air, and there could be more meat, more substance to that. But I think what would be good is if, maybe it's 2 steps ahead, but you can always set out visions. Assuming universities have better understood the matter of value of IP and setting rates in a way that can make sense from an economic perspective, it would be great to set as end goals the public interest rather than just mere commercial interest. So to really value the IP from a perspective of public health and to recognize the need for access as a fundamental aspect in how the rate is being set, which may also make it a bit easier for a company then to meet that criteria. So I think these are all clearly more maybe a bit more operational steps, and where I really see signs of concern is that I'm seeing none of this right now particularly applied. I'm seeing with the greatest concern that we are following more and more narrow national approaches rather than creative international research strategies, which would just assure that we get faster to a result. Maybe in other political areas on which I cannot say what the right thing is or the wrong thing is, this may be okay, but right now it's just really an unpractical thing to do. And we really, really need to give the academics the chance to just ruthlessly and recklessly work with whoever is the right research partner, no matter where in the world they're sitting. And that can have a chance of producing quick results that can bring us back to a normal situation. Yeah.
Thank you, Roya. That was a fantastic tour of the thorny and difficult issue of public-private partnerships. And we've already had a number of comments in the chat.
Oh my God.
Which are very interesting. Particularly, people have raised the issue of remdesivir and Gilead's behavior in terms of setting voluntary licenses only for a limited number of countries. And my colleague Professor Ken Shadlin, who was on the first panel in this series, has pointed out elsewhere that of the 127 countries which were included in the Gilead voluntary license, the whole of Latin America was excluded. So I think your comments were pertinent in terms of the need for greater transparency and greater coordination of some of these initiatives. So you certainly created a good environment for the discussion in the webinar with those comments. There are other comments which I would refer everybody to in the chat facility, but in the interests of time, I'm going to move now to our fourth speaker, and then Roy will perhaps return to some of those interesting points that you raised in the panel discussion at the end. But you link very well with the issues of flexibilities in the public interest by showing us that actually public interest is not just about international trade agreements, but it's also about public-private partnerships. So thanks a lot for that. Our fourth and final speaker today is Professor Danusha Mendes. And Danusha is a professor of intellectual property and innovation law, and also co-director of the Center for Intellectual Property Policy and Management at Bournemouth University. And I particularly wanted to invite Danusha to join us on today's panel because at the end of the last webinar, we had a very lively discussion following James Griffin's presentation about 3D printing. And James was talking about 3D printing in the context of software. And so I invited Danusha to really follow up by telling us about some of her work on 3D printing of ventilators, parts, and face masks and visors. So Danusha, I know you have some slides to accompany your presentation, so I'm going to hand over to you now, Danusha.
All right, thank you, Duncan, and hello, everyone. As Duncan mentioned, I do have some slides, so I'm going to try and share that with you first, and hopefully you can see my slides now. Is that yes? Yep. Yeah. Okay, great. So as Duncan mentioned, I am going to be speaking about 3D printing and following on from the very interesting talk that James gave a few weeks ago. I know James is in the audience as well. And in some ways, so James's talk, I very quickly just say as well, and James can correct me if I'm wrong, but it was about using particular types of software for creating personal protective equipment, PPE, and we got a very good insight into the different ways that it can be done, but also the challenges for IP as well, and also the kind of issues in relation to distribution. So this talk here is kind of taking, I'm trying to maybe go like one step further from that and looking at some of the issues which have apps or in fact have arisen in this current context. So hopefully everyone knows what 3D printing is. You know, you can create various products layer by layer. There's a picture there as well of a particular 3D printer. And my talk really comes from two different, I would say, pieces of work I've done very recently. One is a report that or project that I led and co-authored with a number of other partners for the European Commission, which was about looking at the IP implications of industrial 3D printing. And along with myself, we had partners from Germany, Finland, Austria, and the UK. And in this particular project, what we looked at, of course, it was both a legal and empirical study. So apart from doing a very deep legal analysis, we spoke to 41 industries, and aim was to try and identify the gaps. I know there's a lot of work that's already been done. I've been involved in this field for some time as well, but really try and make recommendations to the EU and see like where we can make changes if possible. And we looked at this from the perspective of 7 selected sectors, and amongst them, health was one of them. So this was something that we looked at for the last 2 years. So it was awarded in 2018, and we ended it in April, as the report was published in April. And then more recently, of course, then there was the pandemic this year, and in May of this year, I co-authored this article with Anna and Grosse. And we asked the question whether 3D printing can in fact help fight a pandemic. So, and I would say in the field of 3D printing, this was one of the times we did see a very coordinated effort, at least in terms of people coming together to, kind of help with printing various types of PPE, and that was really interesting to see. But also at the heart of this whole process is, of course, at the heart of all of this was, of course, the file that would be used by all the different people to print, whether it's a face mask or visor or whatever it was. And the reason why
Anusha, I'm sorry to interrupt. Could you please just turn your camera off, because we've just had some comments that the bandwidth is not great. So we're getting some buffering. And could you try turning your camera off, and we'll see whether that improves the...
Yep. So I'm turning it off and I'm sharing my screen again.
We can't see your slides now, unfortunately.
Yep. I just took it off for a second, but hopefully you can see it now again.
That's perfect. Thank you. Thanks for doing that.
All right. No worries. Yeah. So what I was saying was that in terms of this article, and the reason why we wrote this article is because of something that happened in Italy. And I'll tell the story very quickly. And for some reason I can't. Oops. Yeah, sorry, I couldn't move my slides, but hopefully you can see the slides again. So the kind of story was that in Italy, as the pandemic was kind of going on, there was a hospital in northern Italy, and they were running out of valves, and they were in a really bad position, and they reached out to the manufacturer and said, "Can you please print some, or can you produce some more valves?" But they could not do it in time. And then in desperation, the doctors reached out to a technology journalist. Together, they put out an article. And basically, these two engineers came forward, and then they were able to print the valves that were needed for the patients who were suffering from COVID. And I have actually titled this slide 10,000 to €1. Well, what it was that clearly there was this request from the manufacturers for the file, which, or at the time they wanted to print it, which of course they didn't give. So these two engineers reverse engineered the valve before 3D printing it. And in fact, the information is that the original manufacturers would have cost them €10,000, but with this 3D printing mechanism, they were able to do it for much, much less. So you might ask the question, why was it so much less than the original kind of valves? So there are a couple of reasons, I would say. One is, and the most important, of course, is the intellectual property that lies in that file. So this is, for your information, this is sort of the kind of design file, or a CAD file, as we call it, the computer-aided design file that is used. And this is a very basic one that I have used as an example. But as you can see on the screen, hopefully, the red box, which surrounds something on the, like a construction graph, that's really important, and that's where the IP lies. So, that's one of the reasons why people don't want to share files, because there's the very important IP there. And also, the whole process of manufacturing those valves, it involves a massive amount of actors. So, for example, this is from our report, and you can see the process of 3D printing. And, I'm using the word 3D printing, but actually printing is the very last step in that process. First, you're going to design a file. Then you might want to share the file, or you might want to, get the file to somewhere else. Then comes the printing, then comes distribution and aspects like licensing. And in fact, a very good saying, if I may take a minute, is to say that there's a quote actually that was from about 2010, and it goes, "A 3D printer without an attached computer and a good design file is as useless as an iPod without music." So you can imagine the printer is important, but the software and the file is really, really important. And I'm not expecting to look at anything or read what's on this slide here, but these are condensed conclusions from our report. And I should say the report is something like 250 pages, but there's a very nice 7-page condensed version of conclusions and recommendations, which you can look at. But hopefully through this you can see, again, how IP is that there is there are, like I said, many actors, and also there's a process to go by before you can just hand over those files which are under IP. So when we think of a CAD file, I mean, this is something that there's been a lot of literature on this and a lot of discussion about this, but we can ask ourselves, what type of work is a CAD file? And I'm coming at it from the copyright angle, but of course, you can also from patents, design and trademarks, there are many different aspects to this. So when we look at the CAD file, there's the model that you can see. Then there's the written iteration of the 3D model. That's the bit you can see in the square. Now it's in like a border in blue. And then there is, of course, the CAD file. I mean, this is, I've also put in brackets something called STL file. I don't want to get too technical, but what it is that it's got to be put into a different format to print. So there's like a different version. But if you look at this, like the model, in a copyright sense, it will be artistic work. If it's the written iteration, then, there's a different type of IP there of copyright. And then the CAD file, the question is, can it be seen as a computer work under all the different regulations that we have? So in this context, you can see why, for example, this CAD file was so important or is so important, and why the manufacturers wouldn't give it, and why, for example, when the engineers reverse engineered and did print it, there were also some issues about legal threats. But at the same time, we are in the middle of a pandemic, and in this situation where it's life and death, we ask the question, when it comes to 3D printing and IP in a time of a pandemic, are there things that, we can look at and we can do? So clearly, like we've already heard from other speakers, IP is of course very important for innovation. It is, clearly important for progressing what people have created. But what we also saw from the situation in Italy is that, sometimes when there's almost a starker reality of IP, and that, sometimes it may not always be available what we need, because that IP is sometimes getting in the way. So, is there a way forward? And we have already heard very interesting suggestions from the previous speakers, and particularly with reference to TRIPS and other ways as well, where, there are ways that we can address this. But I just want to give some thoughts before I conclude, particularly from the perspective of 3D printing. And one is, so this is something that is actually taken from the law of finance. And in finance, as you can create a carve out. And again, one of the points that in our article that we published in May, where we asked whether 3D printing can help fight the pandemic, we asked ourselves, can we transport that context from finance into IP, and can we create a carve out which could be applicable when, for example, there's something like a pandemic going on? So how do we kind of deal with that? And I ask these questions. I'm not sure whether I have all the answers, but it's important to ask these questions. And so in that kind of scenario, for example, can we make copies of this life-saving equipment, and can that be exempt from liability? I'm just, again, for the duration of the crisis, is that possible? But then we had to think about, well, obviously, can lead to abuse. And if so, then, can it be that we say, it can be forbidden from releasing the file to follow on innovators? Is that a way that we can address it? And then finally, in this way, by having this carve out, and it's just a suggestion, as I say, it's brought from the law of finance, but in that way, can we encourage innovation and also then promote access to inventions and maximize the use of 3D printing as well as IP rights for the greater public good at a time of a health crisis? So I think that's all I have to say, and hopefully that was, hopefully I wasn't, or hopefully I was clear, and so I'll end there. Thank you.
That was extremely clear, Danusha, and right on time. So if you'd like to turn your camera back on, and apologies for having to interrupt you, when we were getting the buffering earlier on. That was great. So what I'm going to do now is invite all 4 panelists to join me for a discussion during the remaining 15 minutes. This session has been particularly good in terms of the number of comments and suggestions that we've had on the chat function. So thank you to everybody for that. I'm going to start, Roya, with a question that just came in towards the end of your talk, which we didn't have time to address. And this question was from Charlene, who says, my question is, what kind of public-private partnership model would work? Currently, though universities undertake with significant public funding such work, the commercialization is usually done in industry, and the industry is motivated by profit, as I think you already said, and will seek to maximize profit. So in that regard, what model of PPPs would yield better results?
Amazing. This would be totally the subject of a comprehensive research project, which would make an awful lot of sense to start with the people who have just listened in there. I would be reluctant to now give a cooking recipe because I may just say stuff which I would badly regret after I had the time to research on it. Yeah. That's exactly where we need to go with our question. Exactly, yes. That's the point of it. The question we should ask, what do we need to do to motivate people who are in power and who have the money to commission such research? That's the more important question to ask, and I'm happy to explore it with whoever is interested in exploring that. The gist of the question in the end is capitalism, and the fact that how do you manage the profit motive, and that is a very, very big question in intellectual property law. Mm-hmm. And what I see is that we have had a lot of discussions on how to manage the profit motive in property rights. We have not had enough discussions of how to manage profit motive in intellectual property rights. Just not. Many countries don't even get the question. Austria does not get the question. Just not. How could we do it? I think the universities need to team up on having more power, and maybe the many tech transfer offices in every single university need to sort of like work as a cluster towards industry and have a concerted
we had some interesting comments while you were talking as well about the fact that, of course, we're in a global recession, so industry, as they always do, will try and maximize opportunities unless there's some guiding principles in place. And I know at this point, Rochelle would like to come in as well with a comment.
Yeah, I mean, so the United States has been thinking about this a lot because the Bayh-Dole Act was probably earlier than most countries started giving intellectual property rights to universities. And it's called Autumn, the managers, the tech transfer offices of a lot of big universities in the United States have put together a document called 9 Points on Licensing. And it's an interesting document to look at because it tries to do that. It tries to say that you should keep back rights for researchers, you should keep back rights for developments that are going to benefit neglected diseases and countries that don't have enough money to pay patent prices. So that's an interesting document. There's also some interesting stuff that's come from the University of California at Berkeley, because the University of California has been heavily involved in a consortium with BP. I know what position BP is in now, but back when BP had a lot of money. And they've also tried to put together some sort of general ways of thinking about how to make those partnerships work. Now, the 9 points has not been signed by every university, in particular not by Johns Hopkins, where a lot of this research takes place. Not every university that has signed it has followed it, but they do provide at least some ways to start thinking about what those things should look like. Or I don't know, maybe Roya has a different view on the 9 points. The National Institutes of Health have also tried to sort of preach to universities how to handle things, but have not been very successful at it. And part of the problem is that for many tech transfer officers, their own compensation depends on how much money they earn for the university. So it's not just the private company that has a profit motive, but the university itself, the people who are making the decisions do, and that's part of the problem.
Thank you, Rochelle. I'm now actually going to move on to a question from Susie Frankel, which you and Henning may wish to respond to. And Henning, I noticed already in the chat function that you've already posted a few comments in response to Susie's question, but I'd like to give you the opportunity to expand further on that. So Susie Frankel's question or comment was, I agree with your point about 31B bis of TRIPS being primarily bilateral, but 31 and 31 bis are designed for epidemics, whether national or to extent regional, not a pandemic. I won't read the full extent of Susie's question and comment, but essentially she was asking about voluntary licensing. And we also had a follow-up comment from Kimani Goddard on the same point. So perhaps I could ask Henning, you and Rochelle in particular, and maybe Roya as well, if you'd like to respond about voluntary licensing in particular and the potential that there is there.
Well, I think as Susie already sort of finishes in her comment that voluntary licensing would always be preferred because certain aspects might not actually be subject to a compulsory license, or you might have trade secrets involved, or regulatory data protection, which you can overcome to some extent by especially overriding concerns like under a national security exception. And that would also take care of any constraints you have of bilateralism under the Article 31 bis mechanism. But all this compulsion is ideally not the way to go forward. Ideally, we want to have, along the lines of what Roya suggested, a probably less capitalistic approach to licensing and to the individual motivations involved. I don't at the moment see how exactly that's going to work out. So yes, in an ideal world, yes, but I mean, there has been, of course, attempts to address licensing conditionalities in UNCTAD in the 1980s. That hasn't really worked out. So individual countries like China have imposed certain conditions on technology transfer licensing, but that's subject to an ongoing WTO dispute. And the US-China P1 agreement actually scales back on that significantly, so prohibits China effectively from doing any of that stuff. So I guess, yeah, we need the voluntary side of things rather than trying to use compulsion, because that I think is not necessarily the best mechanism, but I'll leave that to others to comment on further things.
Yeah, I mean, my comment to Roya's comment, I mean, those were ideas of voluntary licenses. So the 9 points that the Artem people have pointed out, that's about voluntary licensing for certain conditions. And as I said, some schools do it and some schools don't. It's really very hard to force anybody to enter into a compulsory license. The thing that frustrates me the most is how much government money is going into all of this research. And the government ought to be conditioning that research, those research funds, on lower prices, greater access. There are all kinds of things that the government ought to be doing, and at least the U.S. government isn't. I don't know about the EU and other countries, but the U.S. government is just leaving it to companies to use that money and then acquire the rights and sell them back to the people whose taxes went in support of the invention. Just terrible results.
Yes, I think that point's very well made, Rochelle, about public funding and the fact that the governments are not being sufficiently forthright in demanding access in those agreements. It also links very well with our discussion in the first webinar that we had, which was, we had a discussion about the lack of transparency in some of the licensing agreements which are being put in place. So I think the webinars are linking very well in our discussion of this topic. I'm going to move our panel on a little bit now because there have been a couple of questions which have come in for Danusha Mendes, which I'd like to put to you, Danusha. First of all, I'd like to point out to everybody that Nari Lee has already posted in the chat function a link to your IPR info website report, so people will have access to that. Specifically, James Griffin has asked, in terms of, he quotes from your article and says, in the article you state, however, to avoid an abuse of the expectation post-crisis, follow-on innovators will be forbidden from releasing the digital files containing the instructions for 3D printing and required medical equipment or drugs, amongst others. So having taken that quote from your article, James asks, would this not prevent many useful additions from being made to existing 3D files? For example, people internationally being able to work together to improve a particular 3D printing invention. And Danusha, there was also just a supplementary question which came in from Veronica Rodriguez, who was asking for clarification and insights from you about how the alleged price of €1 for printed valves was calculated. Danusha.
All right, thank you, Duncan. So I'll take James's question first. So interesting question. Thank you, James, for the question. Yeah, I mean, I think one of the things with these files and these CAD files, and we have seen that, is that when you do open it up just generally, not in a pandemic, just generally, and they are available on various 3D printing platforms, then, you know, there have been various issues of other people kind of, you know, infringing the IP of the owners of those files. So of course we're in a very different situation, and we're talking about how we can have coordinated efforts. And I can see why you're asking this question about, you know, can, for example, people add things to those files. I think the issue is, and this has happened more recently even in the UK, is that there have been regulations both from the European Commission as well as our own government about the kind of regulations that we have to abide by when 3D printing manufacturers are creating these files. So it is a difficult situation whereby on the one hand, we don't want IP to be so restrictive, but on the other hand, we have to also think of health and safety, which of course it's not part of this webinar at all. But you know, when we talk of 3D printing, health and safety is at the forefront. So for example, you may remember that we had a batch from Turkey that was flown in, all this PPE into the UK, and then we couldn't use the equipment because it turned out that they were not actually meeting our health and safety standards. So can we open up the files? I think for a coordinated effort, I guess, yes, we can. But then, you know, if we are doing that, and, you know, I think we have to think also of more broadly of those issues like health and safety, and as well as, you know, how, for example, we can rightfully use them with balancing some form of, and also not leading to abuse. So I guess that was like maybe the point that we're trying to make in the article. I hope that answers your question. The other question that Duncan you put to me, it was about 10,000 to €1. So as I mentioned in my talk, this was the information that, you know, I received and I had, and I have tried hard to get to the bottom of the 10,000 euros to €1. I agree with your point that even to print it, it does take a little bit more than that. And I think it was probably, you know, some sensationalized there as well. However, I think it is quite clear that when it comes to IP, there is so much less, when it comes to 3D printing, there's so much less wastage than there is in traditional printing and traditional manufacturing. So, you know, it is very possible that something that costs a huge amount more to do traditionally can cost very much less when you're doing it as a 3D printed item. And of course, here we are talking, you know, of course, face masks are quite big, but this was like valves that were being printed. So, I mean, I take your point about maybe it was quite low, but I mean, the engineers, I should say, actually created, in the first night, they created 100 valves for the hospital to test. Like it was like prototypes, and then they were seen to be very valuable and can be used, and can be used by the patients, and therefore they went ahead and created this huge amount of valves. So yeah, I hope that answers the question as well.
Thank you, Danusha. That's a very helpful and succinct answer. We're nearly out of time, but I want, first of all, to draw attention to the fact that in the chat box, people have been very complimentary about the way the presentations link together very well. And I'd like, perhaps in the just moments remaining, to put a question to Rochelle, because Rochelle, a question came through from Natalie. This is Natalie Stoyanov in Australia, just asking about the march-in rights under the Bayh-Dole Agreement. And Natalie's just asking, what about the march-in rights? Why? I guess Natalie's asking, why aren't they being put into effect?
Why aren't the march-in rights put to good effect? So the march-in rights were created in order for the government to come in and be able to exploit a patent if the people that had the license, or the university who had the original rights, weren't using it effectively. The problem is that at the time that it was created, the Department of Defense was going to march in on everything. And so they created so many hoops that you have to jump through in order to utilize the march-in rights that it's absolutely never been done. You have to prove so much, and you have to go through so many different possibilities that even sort of left-leaning governments haven't done it. And of course, a right-leaning government thinks that it's always best to allow right holders to license for themselves, so they're not that interested in it. But there's certainly been a lot of people writing blogs, etc., arguing that this is a good time for march-in rights.
Thank you, Rochelle. That was helpful clarification. On that point, I think we will end because we are out of time. The discussion has been very fruitful and productive. And as I've said already, we've had a fantastic response in the chat function. I'll share the chat function with our panelists afterwards in case they're able to respond further to any of the specific points that people have raised. Thank you all for joining. We had, as I commented in the chat function, I think 109 participants online. So it's been a fantastic response from people. There will be further issues which we'll want to raise in relation to IP responses to COVID-19 later in this year. So I'm sure this won't be the last of our panels on this, but I'd like to end simply by thanking Rochelle, Henning, Roya, and Danusha for excellent presentations, wonderful interaction with our audience online. And I wish you all a healthy and productive day. And we'll keep in touch about future events. Thank you, everybody, and goodbye.
Thank you.
Thank you.
Thank you.
Bye.